There will be a separate discussion on the uh, other part, which is coming in the text format. My scope is limited to make deliberations on some of the judicial pronouncements. Let us see it from the lenses of judiciary as to how judiciary has interpreted the admission of claim, all things regarding the claims, how it has to be seen, and how we will understand what is the scope and what we have to do in regard to admission with regard to rejection in CIRP as well as in the liquidation process. So if we can understand it from the basic definition perspective, we understand section 3 subsection 6 defines the term claim, which means a right to payment, irrespective whether such right is reduced to judgment, whether such right is fixed, whether it is disputed, undisputed, legal, equitable, secured, or unsecured. This is one part of it. So if you have a right to payment, irrespective whether crystallization has happened by way of a judgment, whether it is fixed, whether it is disputed, undisputed, secured, unsecured, legal, equitable, everything will fall in the definition of a claim. This is one part to it. The second part is right to remedy for breach of contract under any law for the time being in force, if the breach give rise to a right to payment, and again such right whether is reduced to judgment, whether it is fixed, matured, unmatured, disputed, undisputed, secured, unsecured. So these are the two limbs to start with understanding what is the claim. Now, different provision, and if I can just highlight as to what is the legal framework with regard to the subject what we are deliberating. Now, we know insolvency and bankruptcy law has provided that as soon as your company is put to CIRP process and interim resolution professional is appointed, as a first step, the IRP is required to make a public announcement, and by virtue of that public announcement, he invites all the peoples to file their claims, and that has to be done in a time-bound manner. So it prescribes what is the timeline in which the advertisement has to be released by way of a public announcement, which is 3 days from the date of appointment. There is a specified form, there is a specified prescription as regards the newspaper, the place in which the newspaper publication has to go, the registered office, the plant location, and the other places where the material business operations are carried out. And then if a corporate debtor is having a website, then it has to be published on the website also. And if there is a website of a IBBI, then there is a process by which you will submit the application to IBBI, and this this advertisement or public announcement will be displayed on the website of IBBI also. This public announcement inter alia includes the details of the corporate debtor, details of the interim resolution professional, the place from where the forms can be downloaded by the claimant. And if it is a case of a representative of creditor, authorized representative, then it will also indicate necessary details therefore, and it provides a last date for submission of the proof of claims, which shall be 14 days from the date of appointment. And applicant is required to bear the expenses with regard to these public announcements, and committee of creditor, whenever it meets, will ratify these expenses and they form part of the CIRP expenses. In addition to the public announcement, in the year 2022, September 16, the regulation was amended. If you recall, regulation 6A was inserted by way of communication to creditor, and IRP was mandated to send a communication along with a copy of public announcement which he has made in regulation 6 to all the creditors as per the last available books of accounts of the corporate debtor through post or electronic mail, whatever way the information for the communication is available. And if it is not possible because that you don't have a details of the address at which the communication is supposed to be sent, or you don't have the books of accounts from where you can identify as to who all can be the potential claimants, then whatever publication has been done in terms of regulation 6 of CIRP regulation will be considered as deemed communication to all creditors in terms of provisions of 6A also. We were talking about the framework in which we have to read this particular law. So if you see chapter 4 of CIRP regulation, you will get by and large the required details as to what are the claims of different classes of creditor, and how it has to be verified, what is the role, and it has also to be read along with the model timelines which are provided in these regulation itself. From there also we will get some indication, and then we'll figure out as to what is the role in the liquidation, and then we'll straight come to the judicial pronouncements only. Just to give an overview, regulation 7 deals with the subject of claims by the operational creditor, where it says the person who claims to be the operational creditor other than workman or employee, he shall submit a claim along with required proof to IRP in Form B of Schedule 1, and each of these persons are allowed to submit the supplementary document clarification before constitution of committee of creditor. Now, existence of debt is supposed to be proved on the basis of record which is available in the information utility and other relevant document which includes contract for supply of goods or services with the corporate debtor, invoices, any order of the court, or the financial account, and the copies of GST returns. Similarly, if it is a claim by the financial creditor, Regulation 8 deals with the same. Form C is required to be submitted, and record of the information utility. The other relevant documents such as contract for loan, any record which evidences the amount committed by the financial creditor to corporate debtor, any financial statements which evidences any order of the court or such other documents and records as the situation permits to substantiate your claims. There is a Regulation 8A which was inserted way back in 2018 July, whereby the claim by creditors who are in a class was provided a separate form CA, and the existence of debt can be substantiated by records which are available with the information utility, agreement for sale, letter of allotment, receipt of payment that you have made to the corporate debtor, or other documents which are substantiating the claim amount. And creditor in class is also given the opportunity to indicate his choice with regard to insolvency professional from amongst the three choices which have been provided by IRP in the public announcement. This is the additional provision in respect of class of creditor. Now, if it is a claim by workmen or employees, the Form D has to be used, and Form D can be substantiated by records, if any, available with the information utility, proof of employment, maybe appointment letter, maybe contract of employment, maybe any other salary slip, or the statement or the evidences, the communications between the employee and the corporate debtor, and the order of the court or tribunal or the labor court can also be provided. Other creditors have been provided a Form F for the purpose of filing any of the claim, along with, of course, the record of default in the information utility, if any, and any other document which substantiate the claim. The documentary evidence which is in regard to demanding of the money, and the bank statement and order of the court if there is anything. Regulation 10 specifically deals with the substantiation of the claim. IRP or RP may call for any other document, record, evidence, clarification as he may deem fit from the creditor for substantiation of the whole or part of his claim. So that is a specific power that has been given. 11 clarifies that all these processes,
Sir,
whatever
can
cost
I,
is involved. Yeah.
sir, can I ask one doubt? Suppose
Yeah.
the creditors, of course, they may not be aware what kind of form to be used for submitting their claim.
Hmm.
Suppose if the creditor has submitted using a wrong form, can we consider the claim or ask them to submit again in the format, or can we consider
Yeah.
in an appropriate
As
cadre?
far as, yeah, I think there is an unclad judgment on the same subject. If possible, I'll, or maybe I'll confirm the case law also. So the NCLAT has confirmed in black and white that when the form has been used incorrectly, the claim cannot be rejected. The sum and substance remains the same. You may provide the additional opportunity, and it cannot be said that the claim was not filed within 14 days. The claim was filed, only incorrect template has been used for the purpose. So his claim is very clear that he has a claim against the corporate debtor. So denial of the claim cannot be given. Of course, you will request the respective creditor to use the correct form and template along with the necessary supporting document as we discussed, and then you will incorporate in the your claim in your creditor list in during the interregnum period until he submits. You may include in the claim list along with a remark that you have put it for submission again, but claim cannot be rejected merely on the ground that it has not been done. But yes, you can
Yeah,
definitely, that is what
yeah.
we are doing also. Yeah.
Yeah. Yeah, one more thing, suppose if we classify them as a particular type of creditor, and
Ha.
in future, if it has an effect on the sub-distribution water flow mechanism or something, then
Ha.
I think at the time of, considering ourselves the claim as a particular type, we need to take the concurrence of the creditor also, that they may permission that it can be classified.
No, no, no. I'm saying we are talking, you are going to the stage where we are coming to an end. I'm saying ki if he has submitted, let us say he is a employee and he has used the form for the other operational creditor, right? That is one common mistake that the employees are doing or the people who are generally not aware. So we can always include that in our creditor list along with the remark, right? That this has to be this is temporary inclusion in my list, and as soon as the person will submit the correct form, we'll remove this clarification from here, and this amount will become included. He'll be considered as a creditor for that matter, because you are talking about a stage when the liquidation stage will come and he has not submitted any clarification, which is unlikely. If he is not coming reverting back, then I think we'll have to take a recourse accordingly, appropriately, as to why he is not willing to submit when I am giving the opportunity, right? So I don't think that kind of situation ever will arise. The sum and substance, what is flowing from the NCLAT judgment is also that mere using the wrong template
Not
cannot be
to
the
reject the
ground
claim.
for cannot be the ground for rejection, at least. There has to be, if he is not able to, and particularly if your books of accounts are also considering, yes, he's an employee and there is an amount due which you can verify from your records also. So a lot of circumstantial evidences are also to be seen. Now we were talking about can the creditor claim the expenses that he incurs with regard to filing of these claims, with regard to the legal aid or legal help that he has taken. So answer is very clear that regulation 8 of CIRP regulation very categorically says that it is the creditor who has to bear all the expenses, whether he does so directly or whether he takes the help of some legal support. The corporate debtor or the insolvency professional cannot be expected to pay anything over and above what is the claim amount for the towards the cost that he has incurred for recovery of that money. Now, regulation 12 also deals specifically with the submission of proof of claim. And this is very important because there has been a substantial change in this regulation whereby 12.2 has been deleted later on after a lot of hue and cry. Now, creditor is required to submit a claim on or before the last date as has been specified in the public announcement. Earlier, there was a 12(2) regulation which was saying the creditor who has failed to submit a claim within a time specified in the public announcement, which is 14 days, he may submit a claim with the proof to the interim resolution professional or resolution professional, as the case may be, on or before 90th day of the CIRP commencement. Now, this part was deleted in way back in 18th of September 2023, and a proviso was inserted in regulation 12(1) itself, when we were saying that he has to submit a claim within the time specified in the public announcement. Now, proviso says that the creditor who has failed to file a claim along with the proof within the time specified in the public announcement, he may submit his claim along with a proof to IRP or RP up to the date of issue of request for resolution plan. So, earlier position of 90th day, which was sacrosanct, has been amended, and the proviso very categorically says that the time will be up to the date of issue of request for resolution plan under regulation 36B, or 90 days from CIRP, whichever is later. And not only that, if there is a delay, then creditor will provide reason for delay in submission of the claim beyond the 90 days of the insolvency commencement. These are the two provisions which are very important with regard to. So you have to also see there are many judgments available on the internet with regard to the claim. So you have to see whether the judgment relates to period prior to 18/9/2023 or the judgment relates to the period after 18/9/2023, because there is a sum and substance which has been modified effective from that date. So accordingly, when we are interpreting the provisions of law and when we are relying on a particular judgment, you have to see in context as to the judgment period for which it is talking about. Now, if a claim relates to the creditor who is a financial creditor, because it will change the committee of creditor also. So accordingly, the person will be included in the committee of creditor also. A clarification is there inbuilt in the regulation 12(3) itself, that just because the committee of creditor has been modified by virtue of later admission of a particular person as a creditor or maybe financial creditor, and it changes the voting percentage also, this will not invalidate the decisions which have been taken by the committee prior to the date of inclusion. However, this has to be understood in a bona fide manner. If somebody has played foul in terms of rejecting the claim earlier and preventing the bona fide creditor who was to be involved in the CIRP process from the day one, then court has taken adverse view in one of the matter, and I believe a disciplinary proceeding has also been initiated by IBBI in such a case of where the IRP was hands in gloves with the corporate debtor, where he prevented a bona fide financial creditor from getting admitted because his claim was to the tune of almost 90%, and he was supposed to control the entire decision making of the committee of creditor. So we have to be little cautious with regard to this particular fact also. 12A again was inserted in 2021, which was giving an opportunity to the creditor to update a claim as and when the claim is satisfied or partly or fully uh, in any manner after the admission of the claim by the insolvency professional. So as and when you are either paid off or some amount is settled or it is the change, then it is a duty of a creditor to do so and update by way of filing necessary information to the IRP or RP. 13 regulation deals with the verification of claim. Now, IRP or RP is required to verify every claim as on the CIRP date. As we know that everything is prepared as on the CIRP date. So he'll do a verification, and timeline provided for doing such verification is 7 days from the last day which has been prescribed for receiving the claim. And after that, he will maintain the list of creditor, which will contain the name of creditor, amount which is claimed, amount which is admitted, and the security interest in respect of such claim, and will also keep it updated. IRP does not collate the claim after verification if IRP is not able to collate the claim after verification. He has to specify reasons therefore in the note sheet itself as to why he is not able to collate those claims. And if the claims are received after the period which is specified in regulation 12(1), that is the 14 days time, or on or before issue of invitation for resolution plan, or 90 days, whichever is later. If this is the case, or up to the 7 days before the date of meeting of creditor for voting on the resolution plan, or the initiation of liquidation, IRP or RP shall verify all such claim and categorize them as acceptable or non-acceptable for collation. I think this answers the question that was posed by one of the participants some time back. So we are duty bound to give a closer to the decision with regard to collation. At some point of time, it cannot hang on endlessly. If due to certain limitation, because of the want of clarity, want of information, want of document, or so and so, you are putting a remark, you can withhold the collation, and later on, at appropriate point of time, you will be making necessary collation after doing necessary verification, and you will put them in the category as acceptable or non-acceptable. Additionally, within 7 days of categorization, the creditor is also required to be intimated whether it is acceptable or non-acceptable, or will put up the claim as acceptable and collated to the committee in the next meeting for its recommendation for inclusion in the list of creditor and its treatment in the resolution plan as well. And also will submit a claim before the adjudicating authority for condonation of delay and adjudication wherever it is applicable. Details will also be put on the website of the corporate debtor and will also be required to be filed before the IBBI in the prescribed format. They will be also be required to be filed before the adjudicating authority. And of course, when the first meeting of the committee of creditor is taking place, they are presented before the committee of creditor also. Regulation 14 is very categoric on determination of amount of claim, where amount which is claimed by the creditor is not precise due to contingency or any other reason. The IRP will make his best estimate of the amount of the claim based on the information which is available with him, and basis that he will include that amount in the list, and as and when the estimate becomes confirmed or he is provided with the additional information, then he will make necessary revision also with regard to the claim. On this particular point of contingency, I think this is very important. We'll deliberate a bit more and we'll see some of the legal cases also. I think SR Steel case has given a lot of guidance to all of us. We'll review those matters also. And one last point with regard to the debt in the foreign currency. Any claim which is denominated in the foreign currency will be included in the Indian currency at the official exchange rate as on the date of CIRP, irrespective the date on which they are filed. Filing date is irrelevant because you have to crystallize everything as on date of the CIRP. So you have to see what is the Reserve Bank of India official exchange rate on the date of CIRP for the purpose of conversion of foreign currency claims into your list of creditor. Now, regulation 40A, which was inserted later on to provide certain model timelines. I think let us quickly have a glance over those provisions also, and then we will come straight to the legal cases, and from there we will, if required, we'll come back to the respective regulation also to understand as to how it has been prepared in the how it has to be done. So model timeline says that commencement of CIRP is, let us say, T date. Within 3 days, you have to make a public announcement. Within 14 days, the claims have to be submitted. Submission of claim is up to 90th day or the publication for invitation for resolution, whichever is later. Verification will happen within 7 days from the filing of the claim. And application for appointment of authorized representative has to be done within 2 days from the verification. So receipt of claim 14 days, 7 days verification, and therefrom within 2 days you have to make an application to the adjudicating authority, that is T plus 23. Essentially you will be doing so, and report which is certifying the constitution of committee will also be submitted simultaneously in T plus 23, and first meeting of committee of creditor will happen within 7 days of filing of report certifying the constitution of creditor, that is T plus 30 days. And if a same resolution professional is continued as a RP or there is a change, accordingly the resolution to appoint RP will be taken up at the first meeting, and appointment of RP on approval of adjudicating authority will be made. And till the time RP is taking charge, the IRP will continue the functions of RP, and appointment of valuer and the so on so forth process. I think it is not required for the today's discussion. He will do simultaneously lot of other actions also, and there are certain forms also which are required to be filed with the CIRP 1, CIRP 2, CIRP 3, CIRP 4, and so on so forth in regard to these processes, whatever are prescribed. Now, coming to the subject of claims, one of the most disputed point in the insolvency resolution has been applicability of law of limitation, and there are n number of judgments on the subject, including from NCLT, adjudicating authority, to the highest court, that is apex court. And there is a change in the legal position also by express inclusion of a provision in the insolvency and bankruptcy code as well. If you read the provisions of section 238A, which has been inserted later on by virtue of amendment. Give me a second, let me open also. Yes. So 238A, which was inserted by virtue of amendment made with effect from 6th of June 2018. 238A says the provisions of the Limitation Act 1963 shall, as far as may be, apply to the proceedings or appeals before adjudicating authority, National Company Law Appellate Tribunal, Debt Recovery Tribunal, or Debt Recovery Appellate Tribunal, as the case may be. So, in a sense that whenever the matter is placed before the adjudicating authority or competent adjudicating authority and its appellate authority, the provisions of Limitation Act 1963 will apply on proceedings as well as appeal. Because for corporate person, the adjudicating authority is National Company Law Tribunal and appellate authority is National Company Law Appellate Tribunal. And for individual, the Debt Recovery Tribunal and Debt Recovery Appellate Tribunal. So they have made its application basis this particular provision. Now, the provisions which have been interpreted by the various judicial pronouncements. The first pronouncement which I want to place for discussion was BK Educational Services Private Limited versus Parag Gupta and Associates. This was 2018 judgment. And the judgment says the provisions of Limitation Act were made applicable to the insolvency proceedings by introduction of 238A in the IB code by virtue of the Second Amendment Act 2018. This has bring a clarity that it has a retrospective application because the intent of law is not to revive the time barred debts. This was the outcome of BK Educational Services versus Parag Gupta in 2018. This put a rest to the dispute whether it is retrospective or it is prospective, because this amendment was done with effect from 6th of June 2018. So the question which was before the my lords was whether it will be having a prospective application or it will have a retrospective application, and the law was clarified that it is a retrospective, because intent is not maybe the law came into force with effect from 1st of December 2016. That does not mean ki uh, uh, prior to we have to, from which date we have to consider the limitation. And Honorable Apex Court in this matter also clarified that the period of limitation for filing application for initiation of insolvency proceeding will be 3 years from the date of default, as if you go to the Article 137 with regard to the limitation law, that provision will be applicable for the insolvency matter. Section 18 provides that if a written acknowledgement of liability is given prior to its expiry, the fresh period of limitation shall be computed from the time of signing of such acknowledgement. And the effect of Section 18 is not to revive a debt, but the recovery of which is a time barred as per the Limitation Act, but only to extend an existing period of limitation. So that means ki if you have a evidence of acknowledgement, then your period of limitation will stand extended. So Supreme Court put a clarification on that particular aspect also. Another matter wherein the limitation principles were considered, which is landmark 1, was Lakshmipat Surana versus Union of India, which was a 2020 judgment. And this judgment settled the issue with regard to applicability of Section 18 of Limitation Act to initiation of insolvency proceeding under IB code. Apex Court stated that Section 18 of the Limitation Act applies to extend the period of limitation for filing an application under Section 7 of the IB code. In the matter of Babulal Gurjar versus Veer Gurjar Aluminium, it was dealing with the question whether application under Section 7 of IB code is time barred, given the default occurred in 2011. In this matter, Supreme Court examined the applicability of principles of Section 18 and observed that the observation made in judgment were relied upon in subsequent decisions of NCLT and NCLAT to hold that Section 18 would not apply to applications for initiation of insolvency proceeding of Insolvency and Bankruptcy Code. What it stated was bringing a new dimension. This was a judgment which brought another dimension, that for initiation of CIRP proceeding, because they are not recovery proceeding. So when somebody is filing an application for initiation of CIRP, it is not recovery proceeding. So there should not be applicability of Section 18 to these applications. And court also clarified that its decision in the Babulal matter did not rule out the application of Section 18 and observed that Apex Court has not ruled out the application of Section 18 of the Limitation Act to the proceedings under the code if the fact situation of the case so warrant. Apex Court held when a principal borrower or the corporate guarantor admits and acknowledges the liability, a fresh period of limitation is required to be computed from the time when acknowledgement was so signed by the principal borrower or the corporate guarantor, provided it has not expired prior to that continuation period. And in relation to liability of a guarantor, Apex Court reiterated that such liability is coextensive with the principal borrower under Section 128, although that is not subject. And Supreme Court found no reason to exclude the applicability of Section 18 in the IB Code and Article 137 of the Limitation Act, which provides that the period of limitations runs for the period of 3 years from when the right to apply accrues, is applicable in the computation of limitation period under CIRP also. After the landmark judgment and ruling in the Lakshmipat Surana, a larger bench of Apex Court in the Arcel versus Bishal Jaiswal observed that not only Section 18 of the Limitation Act is applicable to the proceedings under Insolvency and Bankruptcy Code, but also held that the entries made in the books of accounts, including the balance sheet of debtor, will also tantamount to acknowledgement of debt under Section 18 of the Limitation Act. The observations of Apex Court in the matter of Sheshnath Singh and another versus Baidyabati Shura Fully Cooperative Bank are also worth consideration. Apex Court stated that the limitation law must be read harmoniously as far as may be possible with the Insolvency Code. An application for condonation of delay is not mandatory to seek condonation under the provisions of Limitation Act. Proceedings under SARFAESI should be deemed to be civil proceeding under the contours of Section 14 of Limitation Law and should be excluded while computing limitation under insolvency code. That is also one clarity which came by virtue of this celebrated judgment of Sheshnath Singh. And it also stated section 5 and 14 of the Limitation Act are not mutually exclusive. And the principles of section 14 may be used to construe a sufficient cause under section 5. So they are to be read in harmony. Another important matter on the subject of limitation was Dena Bank versus Shiva Kumar Reddy 2021 judgment of Apex Court, wherein it was held that application under section 7 of Insolvency and Bankruptcy Code will not be time barred by limitation on the ground that it has been filed beyond the period of 3 years from the date of declaration of loan account of corporate debtor as NPA. If there was acknowledgement of debt by the corporate debtor before expiry of period of limitation of 3 years. So which will get extended by the period of 3 years. It also stated that a judgment or decree for money in favor of a bank or the financial creditor which is passed by debt recovery tribunal or any other tribunal or court for issuance of certificate of recovery in favor of financial creditor will give rise to fresh cause of action to the financial creditor to initiate proceeding under section 7 of IB code for initiation of the CIRP within the period of 3 years. Now, another dimension with regard to the limitation, this was from initiation of CIRP. The other aspect which comes to mind for deliberation is what would be application of law of limitation in case of claims. If a claim is time barred, whether IRP or RP is duty bound to consider the law of limitation while making non-acceptance while doing a verification and collation. Whatever legal principles have evolved so far, they only suggest that the limitation law has not been excluded from its applicability with regard to insolvency and bankruptcy code, and apex court in time and again many matters have stated that they have to be read in harmony. So the logical conclusion that we can draw would be same as we have discussed with regard to the filing of application. Same principle will apply for the filing of the claim also. So I'm not repeating those all judgments for its applicability in the filing of claim as well. Another important point which has been deliberated, I think, by apex court in the matter of Mobilox Innovation versus Kirusa Software. This is known for other subject matter, which is a dispute in case of operational creditor. But this judgment also clarified that insolvency and bankruptcy code is not a recovery code, is not a substitute of a recovery mechanism. It is not intended to substitute a recovery forum. And then it went on to the subject of dispute. So in the context of dispute, though this ruling was made, but it has a universal application in respect of understanding as to what kind of forum is created by virtue of insolvency and bankruptcy code. Now, let us also, we have parked one issue with regard to the contingency and the dealing of the contingent claim. As we know, insolvency and bankruptcy code provides for a collective resolution mechanism. And claims from the multiple creditors of different nature are collated by the RP or liquidator, and which are then repaid either under the resolution plan or in the liquidation by way of recovery, which is made either pursuant to resolution plan or by way of a realization by the liquidator in the liquidation process. Therefore, to be in a position to recover their dues from the corporate debtor, it is most important that the parties qualify as a creditor with legitimate claim under the code. So this is very important aspect while we are considering and processing the claim. Now, crystallization of claim can be easily accounted for. The problem lies where claims are contingent or unascertainable. Crystallization is not happening today, not a problem. Maybe 6 months down the line, the crystallization will happen. I have a certainty. Difficulty lies more in respect of contingency or unascertainability. And this impact the valuation of these claims, inclusion in the list of creditor, constitution of committee of creditor, voting right. You can imagine what could be the implication and impact of contingent claim on the entire CIRP process. There are various judicial pronouncements. The law, maybe one can say with the guidance given by apex court in many matters, including SR, but still the questions remains, which has to be dealt by the RP or IRP on a case-on-case basis, understanding what the evolution has taken place over a period of time. The question that we should debate should be whether the term claim, as is defined in section 3, subsection 6 of the IB code, include in its purview the contingent claim. We have seen the definition. We have started our discussion with the definition of claim. And if yes, what would be the relevant factor for assigning a value to these claims? Another important question, whether the concerned creditor will form part of the committee of creditors. Let us again come to 3 clause 6, where the claim is defined to mean a right to payment and right to remedy as is defined in the 3 clause 6. Right to payment underscores a right to claim. If there is no right to receive payment, no claim exists at all. Whether or not such a right is reduced to judgment and so on and so forth. To fall under the claim, right to remedy must give rise to right to payment, whether or not such right is reduced to judgment and so on and so forth. So the expression claim, which is defined in 3 clause 6, has two parts. One is right to payment and second is right to remedy for breach of contract if such breach gives a right to payment. So right to payment, irrespective of its nature, can be fixed, disputed, undisputed, secured, unsecured, legal, equitable. And debt, which is defined in 3 clause 11, also to be understood while understanding the term claim. Debt involves a liability or obligation to which to make a payment which is due. So debt involves a liability or obligation to make payment that is due for the. Now, unfunded exposure do not involve any outlay of funds on the part of the financial creditor. Under IB code in 5 clause 8, the term financial debt has been defined and the stress is on the amount disbursed, not on the obligation or undertaking to disburse. Hence, there is no debt. If there is an ongoing commitment, which if fructifies, will entail a right to recovery. In the scenario which we discussed, the right to payment may not be existing or immediate, but it could be contingent also. Debt is contingent one, whether such contingent debt can give a rise to a claim. That is the attempt that we are going to make in understanding, and we can interpret the judicial pronouncements also in this regard. If you go to the principles of accounting standard defines the term liability as a present obligation which is arising from past event, but the settlement of which is expected to result in an outflow embodying economic benefit. So there are three components: present obligation arising out of past event, and settlement is expected to result in an outflow of resources. Now, what is obligating event in the accounting standard? Obligating event is the event that creates a legal or constructive obligation that result in an entity having no realistic alternative to settling that obligation. That is the trigger event. Basically, that is the obligating event. Legal obligation in terms of accounting standard is an obligation that is derived from contract, that is derived from legislation, or that is coming from an operation of law. There could be a case of a constructive obligation also under the accounting standard. Constructive obligation is obligation that derives from the entity's action when by established pattern of the past practices as per the published policy, or as a result the entity has created any valid expectation on part of the other parties that it will discharge those responsibilities. In those situations, the constructive obligation can also give birth. Contingent liability is very interesting to understand in the backdrop of the accounting standard. Accounting standard defines the contingent liability as a possible obligation which arises from past event and existence will be confirmed only by occurrence or non-occurrence of one or more uncertain future event. And those events are not in the control of the entity. I have no control. So it is the obligation where there is a probability, and these obligations are arising from the past action. But its existence is not confirmed. Existence is confirmed on occurrence or non-occurrence of event which will take place in future. And these occurrences are not in the control of the entity. This is one. Or contingent liability could be a present obligation which arises from the past event but is not recognized today because it is not probable that outflow of resources embodying the economic benefit will be required to settle the obligation, or the amount of obligation cannot be measured. So these are the two reasons due to which the present obligation which has arisen from the past event, but still it is not recognized, either the probability of outflow is not certain or amount is not measurable today. Now, while we are discussing the contingent liability, we should also understand the difference between the provision versus liability. Now, provision is completely different. Many a times the insolvency professionals do error while making a distinction between these two terms. In case of provision, there is no uncertainty with regard to happening of that event. So provision is distinguished from the liability which could be a trade payable, accrual, because there is a uncertainty about the timing or amount of future expenditure required for the settlement. Whereas in the case of liability like trade payable, they are firm. But in case of provision, there is an uncertainty about the timing or uncertainty about the amount of future expenditure required for the purpose of settlement. And provision versus contingent liability are also different. As we discussed, in case of contingent liability, there is a contingency and there are certain elements which are required to be fulfilled. In case of provision, all provisions can be considered as contingent because they are either uncertain in the timing or they are uncertain with regard to the amount. Let us see how the treatment is to be done in the balance sheet in terms of the accounting standard with regard to the contingent liability. The accounting standard says the entity will not recognize a contingent liability. Contingent liability, as we are aware, is disclosed in the financial statement by way of a note to the accounts, giving certain information with regard to those contingency factors. Now, if you see the legal framework under the Insolvency and Bankruptcy Code, 3 clause 19 of the IB Code defines the insolvency professional and 5 clause 27 defines the term resolution professional. And if you come to section 18(1)(b) of Insolvency and Bankruptcy Code, it says IRP is responsible to receive, collate, and verify the claim. And IRP shall perform duties, receive and collate all the claims submitted by the creditor to him pursuant to the public announcement which is made in terms of the provisions of the IB Code. So, as per section 18, it is the duty of the IRP to collate the claim, and word collate means collect, compare, to verify and arrange it in order. The power of IRP is administrative. It is not adjudicatory. As against the power of liquidator, which is quasi-judicial, which is adjudicatory, IRP may reject the claim if it is submitted after the stipulated timeline or it is submitted without sufficient evidences. And the creditor will have a right to file an application under section 65 before the adjudicating authority against the action of the IRP. Now, if you go to regulation 13 that we have discussed regarding the verification of claim, IRP shall verify every claim on the CIRP commencement within 7 days and will prepare a list of creditor and do the respective actions for the purpose. Now, in the matter of Committee of Creditor of SR Steel versus Satish Kumar Gupta, which is on regulation 13. This is also a very big judgment and different subjects have been touched. But regulation 13 of IBBI CIRP regulation is also one of the important subject matter of interpretation by the apex court in this matter, where it has mentioned the resolution professional shall verify each claim as on insolvency commencement date and thereupon maintain a list of creditor containing the name of creditors along with the amount of claim, amounts admitted by him, and the security interest, if any, in respect of such claim, and constantly update the aforesaid list. In the matter of Swiss ribbon, it was categorically specified by the apex court that the RP or IRP is having no quasi-judicial power, but these powers are limited to administrative. And court stated that it is clear from the reading of these regulation, that is regulation 13, that the RP is not given any quasi-judicial power, but his powers are administrative. Coming back to one more important deliberation made in the matter of Navneet Kumar Gupta versus Bharat Heavy Electricals Limited. In this matter, it was held that RP cannot reject the claim without taking the evidence which substantiate the claim into account. In this matter, as you are aware that RP has rejected a claim, to that the apex court stated that RP is not having a power to reject the claim without considering the evidences which substantiate the claim into account. RP in this matter has disallowed the substantial amount of claim in its entirety, and the RP was directed to re-examine the claim on the basis of accounts and evidences of BHEL. And if the evidence corroborated that the claim exists, the same should also be taken into account while finalizing the total claim. The question which arises for consideration in this appeal, whether the RP has jurisdiction to reject the claim of BHEL in its entirety without going into the evidences. As far as regulation 14 and regulation 25 of liquidation process is concerned, 14 of CIRP and 25 of liquidation process regulation, the creditor who is submitting a claim will be responsible for the cost. if a creditor claim is not precise, RP, in accordance with regulation 14, will make the best estimate of the claim value on the basis of information what has been received by the RP. And if RP provides further information, then he will be duty bound to update the claim amount. On regulation 15, there is one judgment which was with regard to a subject of penal interest in the claim. In the matter of Central Bank of India versus Ravindra and others, it was stated that if there is an element of penal interest also in the claim, the penal interest can form part of the claim, but no interest is chargeable thereafter. So penal interest subject was clarified in this matter of Central Bank.
What is the case, sir? Can you repeat?
It was in the matter of Central Bank of India versus Ravindra and others. This was, I think, 2020 judgment. Now, unproven claim. How it will be read and who will be responsible? So the regulation 15 of the CIRP regulation is very correct and very crystal clear that the cost, if any incorrect claim is submitted, the cost of verification and determination will be recovered from the applicant. If you are doing that, you have to follow the process by filing an application. Now, regulation 15 has also given a SOP in various judgments. And one of the important functions of the IRP or RP is the substantiation and verification of the claim of the creditor. And courts have laid down that you have to follow the SOP, wherein as a first point, all claims must be listed immediately on their receipt and document received must be digitized. Categorization and listing all claims as a financial creditor, as an operational creditor, or as a other creditor has to be done as a second step. Claimant under each category has to be subdivided, whether such financial creditor is a bank, or it is a NBFC, or it is a asset reconstruction company, or it is a lending institution like IDBI, UPFC, or it is a debenture holder. Then you have to prepare a note sheet for each and every claim, each and every creditor, recording the scrutiny or verification of documents which are submitted by the claimant and the observation and the decisions of the IRP, RP in this regard, so that whenever RP takes over, he is having a ready information from there he can proceed with. Or even for future reference of the RP also as to what all he has to inquire or ask from the respective claimant or the creditor. Then he has to prepare and update the list of creditor including the details such as what is the date of receipt of a claim, what is the name of claimant, what is the amount claimed, what is the date of scrutiny verification, amount of claim which is substantiated, amount of claim which is non-substantiated, whether it is secured, unsecured, and obviously you will add your remarks also. So all claims are to be prepared in this format in the Excel, and you can add your note sheet, and the list of creditor can also be prepared in the separate worksheet so that that can be continuously updated.
And there is no prescribed format for claim
No
list of.
prescribed, no prescribed format, but I think now it's been more than 7 years. I think each of the RP is having that standard template, which may be little bit tailor-made to suit to the particular requirement. Otherwise, by and large, what we have discussed are the
Contents
requisite
of that.
field content. And everyone is preparing in its own format. Now, how much note you want to add, what is the amount that you have added in the substantiation, because each and every claim has to be reviewed. Objective is very simple. We have to go with the objectivity approach that tomorrow it should not happen that you have to open the claim file again and again. You have to find out as to what is the reason, and maybe many a time the claimant will ask, make a phone call just to understand as to what is the status. So if you have something in your Excel format prepared, it will be easy to respond him, and he can also easily note it down and accordingly inform to the claimant as to what all information is required. And lastly, whenever the valuation report is received by the RP, the list of creditor will be required to be recasted in terms of the provisions of section 53(1), read with section 30 clause 4, incorporating the value of security interest. So while you are preparing your list of creditor today on the receipt of your claim, you also have to bear in mind that future you have to put it in a format that the requirement as per section 53(1), after receiving the valuation report and assigning it a secured, unsecured character, are also easily facilitatable. It should not happen that tomorrow you have to do the again same homework and you are not able to complete that process. On the disputed claims, I recall one judgment which gives us some guidance as to how we should account for the disputed claims. In the matter of SSMP Industries versus Perkin Food Processors Private Limited, it was clarified that since the proceedings before the adjudicating authority are summary in nature, the insolvency are summary proceedings, the adjudication of disputed claim for determination of value must continue out of the insolvency proceedings. Where it is not possible for the adjudicating authority to decide a claim on the basis of disputed fact, it will be decided by the court of competent jurisdiction only. And I believe Apex Court has, in the matter of one of the Noida authority, also reiterated the principles which had evolved from the SSMP industries only. So wherever you have a disputed claims. Now, this is a very thin line. Somebody can say a creditor has filed a claim and RP has a dispute over the same. Now, whether each and every matter will go to the separate court of law for the purpose of adjudication? No. You have to see if it is not adjudicatable in the summary proceedings before the adjudicating authority. Then only it will be required to be sent to a separate court for the purpose of crystallization of the amount or dispute. If it requires a greater degree of evidencing, which may not be possible in the summary proceeding, then only it will be required to be sent. Otherwise, the intent of code is very clear that the power lies with adjudicating authority, and adjudicating authority shall be seized of such adjudication proceedings also. But if it is a disputed question which cannot be settled and which cannot be decided in the summary proceeding, then these matters will be required to be referred to outside. In the liquidation proceeding, the liquidator has to consolidate and verify the claim and either admit or reject the claim under section 38 to 40 of the code. If you see section 41 and 42, by way of a contrast between the powers of the liquidator and the powers of the resolution professional, what they provide, 41 deals with the determination of valuation of claim. Liquidator shall determine the value of claims which are admitted under section 40 in such manner as may be specified by the board, which has been specified by the liquidation process regulation. Appeal against the decision of the liquidator. Any creditor who is aggrieved with the order of the liquidator will have a right to appeal before the adjudicating authority against the decision of the liquidator, accepting or rejecting the claim within 14 days of the receipt of such decision. Yeah, somebody was saying something.
Sometimes the video is breaking. That's it. Okay.
Yeah, all right. Now, let us travel a bit further, because a lot of time courts have considered the principles of ancestral, the jurisprudence which has evolved from the ancestral. So let us understand what is the position in the ancestral with regard to the conditional, contingent claims under the Insolvency and Bankruptcy Code. The section 171 of this particular ancestral guidance, the guidance was the insolvency law should specify that the claims that may be submitted include all rights to payment that arise from the acts or omission of the debtor prior to commencement of the insolvency proceeding, whether they are mature or not, whether liquidated or not, whether fixed or contingent. This was a mandate under the ancestral. Guidance given was where the amount of claim cannot be or has not been determined at the time of claim to be submitted, many of the insolvency law allow a claim to be admitted provisionally, subject to giving it to a notional value and determining a value of such claim later on. An important reason for permitting the provisional admission is to allow creditor who is holding these claims to at least participate in the insolvency proceeding, and in particular vote also on the key issues which require the approval of the reorganizational plan. And provisional admission will generally entitle the creditor to participate in the proceeding to the same extent as other creditor, except that they may not be entitled to participate in the distribution until the value of the claim is admitted. That is the position. If you see the global scenario in US, the term claim under the US bankruptcy code is also providing the extensive definition and uses the contingent claim in the US code. In UK, section 382(3) provides that all claims that are treated as a debt or liability, whether they are present or future, certain or contingent. So UK law also has included contingent claims in their claims definition. Now, if you see the position under Presidency Towns Insolvency Act of 1909, which was prevalent prior to coming this law into force, section 46 provided that an estimate shall be made by the official assignee of the value of any debt or liability provable aforesaid, which by reason of it being subject to any contingency or contingencies or for any other reason did not bear a certain value. So there was a specific mention and a specific provision also in the law. So what is the conclusion? Conclusion is there is no specific reference to the word contingent claim under the insolvency and bankruptcy code, unlike specific mention in the US code, in the UK code, or in the previous insolvency law. However, considering the established principles of law, we can say that these kind of contingent claims are not to be excluded, as Supreme Court has given a guidance that we will include them on the provisional basis and we'll keep on making efforts on the later on basis, and we will accordingly consider and settle those positions. If we go and see the few judicial pronouncements also, Axis Bank versus EduSmart is one judgment of adjudicating authority starting in 2017. And in this matter, the bench has referred to the provisions of section 13, which provides that RP is required to verify each and every claim. And they have stated that it is evident that in order to qualify as a debt, firstly, the provisions, the corporate guarantee must be satisfied by raising a demand, which is expressed by invoking the corporate insolvency date. And in this case, the CIRP commenced in 2017 June, and the corporate guarantee was invoked later on, which was after the insolvency commencement date. So in this case, the court observed the RP would not be in a position to verify the claim, as it would not reflect in the books of account, which were supposed to be updated as on the date of commencement of insolvency. In absence of any record to verify the claim, it will be impossible for the RP to accept such kind of claim in these scenarios. And to substantiate their argument in this matter, the adjudicating authority also referred to the definition of a claim and the debt, and adjudicating authority also made a reference to the moratorium provisions under section 14 1C of the IB code, and observed it is abundant clear that there would be a moratorium prohibiting any action to foreclose, recover, or enforce any security interest created by the corporate debtor in respect of property. So they mentioned that the invocation of corporate guarantee against the corporate debtor, respondent would result in enforcing security interest, and thus it would be violating to the principles of section 14. Now this judgment, this was a principal bench judgment, was also relied upon subsequently in Benani Cement, in the JEKPL of NCLT Allahabad matter, and several other matters as well. In this matter, there was an appeal before NCLAT in 2018. And in that appeal, it was held that the claims under non-invoked corporate guarantee have to be admitted as a contingent claim. If you refer the para 56 of the order of 14th August 2018, the Milords have held that the maturity of a claim or default of a claim or invocation of a guarantee for claiming an amount has no nexus with filing of a claim pursuant to the public announcement. For the purpose of collating information relating to the assets, finances and operations of the corporate debtor, or the financial position of the corporate debtor, including liabilities as on date of the commencement of CIRP, it is duty of RP to collate all the claims and to verify from the records of assets and liabilities which are maintained by the corporate debtor. That was a logic given, and it was decided that it will be included. Now, continuing this journey forward, in 2019, Honorable Apex Court, in the matter of Committee of Creditor versus SR Steel, of SR Steel versus Satish Kumar Gupta, stated that a resolution applicant who is successful cannot suddenly be faced with undecided claims after the resolution plan submitted by him has been accepted. And if this is allowed, then it would be amounting to a hydra head popping up, which would throw the uncertainty amounts payable by the prospective resolution applicant and might fail the resolution plan in its entirety. So that cannot be the intent. So it has to be admitted. The judgment of NCLET previously in the matter of Educom was in a way upheld by the Honorable Supreme Court in the matter of SR Steel.
Then
So
as a
now,
result,
yeah,
as a result of this fluctuating claim amounts, the voting shares of the financial creditors go on changing, which will have an impact on the decisions from COC to COC meeting to COC meeting.
so that is the reason why there are so many litigation, because I agree, means we have been deliberating now for quite some time, and we understand, because courts are also perplexed with the difficulty as to how, because what Supreme Court while was reviewing the matter of SR Steel, was reviewing it from the successful resolution applicant perspective, and was seeing it from that perspective. It cannot be left in lurches after the resolution plan is approved. Now, if you are not including in the claims, then what will be the position? The position would be that the successful resolution applicant will definitely not be able to know about these kind of contingent claims.
Hydra head
So
keeps on popping up.
they will keep on popping up, and they have a potential to destroy the entire resolution plan, which is against the spirit of insolvency and bankruptcy code, because the law intends to bring a particular action to an end by way of maximization of value, whatever it can be. But some point of time, in a time bound manner, it has to be concluded. After that, even if you see the provisions of section 32A, which were introduced later on, so anything and everything which was required to give us certainty to whatever conclusion has been made by the adjudicating authority in resolving that particular matter has been ensured by way of a legal provision also later on. So I believe you are right. Whatever difficulties are being faced, whatever challenges, so the apex court in many other matters have mentioned that there are enough checks and balances, enough powers are there. If somebody is playing around by manipulating these voting powers, then I think there are sufficient checks and balances which will take care of these kind of manipulating practices. But in no situation this could be left in lurches, where your entire CIRP process is completed and the fag end the person claim is admitted by that time, because the law says that whatever process has been completed, those will continue to be enforceable. So he should not be left into difficulty. I think that was the logic behind. But I completely agree that these kind of challenges are
And
there, and these challenges will continue to be there. Yeah.
and one more thing, sir. Suppose if it's a going concern and some fresh guarantees are issued within the limit
Huh.
sanctioned, these will come part of CIRP cost only. No? You got my point?
Personal guarantees
Not
are
personal
issued.
guarantees, not personal
Huh.
guarantees.
Huh.
Bank guarantees which are approved by the COC during the process of CARP.
So it is the interim finance only, na? So
Yeah,
bank
interim
has
finance.
given, yeah, it is the interim finance only.
Okay.
Yeah, possible, because many of the entities which are going concern, they have
Yeah.
to submit these bank guarantees for the purpose of getting a company ongoing, CD ongoing, and completing their contract. So that is possible that these bank guarantees could be issued during the CIRP process, and this will definitely be a
So
part of the.
whatever outstanding bank guarantees as on the date of claim, that are to be taken as a claim, not the unissued. I mean, within the limit and
Yeah, subject to that, and you will keep them as provisional, and as and when they crystallizes, accordingly you will be making a necessary treatment thereof. So I think we have fairly discussed on this particular aspect with regard to this. Let us move to couple of more legal cases. I think one which is very close to uh, my heart, and one which is creating a lot of difficulties also, is with regard to the arbitration, the arbitration award, and the impact thereof in the insolvency proceeding. The legal cases surrounding those matters as well are to be or can be evaluated while we are discussing this particular part. Now, first question which comes to discussion is on a point whether the CIRP proceeding can be initiated while the arbitration award has been passed. I think this is an open and shut case which says that IBC cannot be invoked when the arbitration award has been passed against the operational debtor and the same is under appeal. This will not be the ground, and this was held in the matter of K. Krishnan versus Vijay Nirmal Company, while this was an NCLAT judgment. In the matter of Indus Biotech versus Kotak Venture Fund, the issue was whether the arbitration can be invoked during pendency of insolvency petition. This matter went up to Supreme Court, and Supreme Court addressed the issue which was contentious in cases where Section 7 petition has been filed. The court observed that the key determinant of the arbitrability of the dispute is not simply the filing of Section 7 petition, but rather the point at which the petition is admitted. And it was determined that when a dispute involving REM matters, those affecting the rights of the public or a group fall outside the purview of arbitration and are not within the jurisdiction of arbitral tribunal. Supreme Court held that the stage at which a reference to arbitration is sought prior to petition's admission is critical. And they have referred many of their previous rulings also. One of the ruling was Vidya Drolia versus Durga Trading Corporation. And in this matter, Supreme Court has laid down the criteria for determining whether the dispute is non-arbitrable. It was held in this matter, the disputes become non-arbitrable when it involves non-REM proceeding, which under IB code occurs only after petition has been admitted. So Supreme Court reiterated that the Section 7 petition to initiate the REM proceeding, the adjudicating authority must conduct a detailed examination, establish the occurrence of default, and formally admit the petition. This admission will trigger right of all creditor of the insolvent entity. Therefore, mere filing of the petition without its admission does not convert into case into rem, and accordingly Supreme Court held that the admission of petition of CIRP is important milestone which will determine the nature and status of the proceeding. So until these proceedings have been initiated, the arbitrability or the arbitration invocation cannot be stopped and these proceedings can continue or can be initiated. Another matter which was regarding the presence of the arbitration clause in the agreement, how it impacts the insolvency proceeding. This matter came up for discussion in the Tata Consultancy Services versus Vishal Gisulal Jain. And in this matter, Supreme Court held that the existence of a clause for referring the dispute between the parties to arbitration does not oust the jurisdiction of adjudicating authority to exercise the residuary power under Section 60, Clause 5C of the IBC to adjudicate the disputes relating to insolvency of a corporate debtor. The adjudicating authority is not limited by Section 14 of the IB Code in terms of reasons for the judicial intervention contemplated under insolvency and the bankruptcy code. Under Section 65C, it can use the residuary jurisdiction to rule on the legal and factual issues which can arise from the insolvency resolution process. Similar view was taken from the Mitcon Consultancy versus Vitthal Corporation, and accordingly this view was settled just because the arbitration clause was existing in matter. This does not rule out that the Section 65C residuary jurisdiction cannot be used for the purpose of settling that. It is not mandatory that it has to go in the arbitration proceeding only. Adjudicating authority will be having a power. Another important dimension I think we must understand is regarding the time barred claim. Again, the subject of limitation from where we stopped the thread, by and large we have discussed, but time barred claims are important for all of us as an insolvency professional to understand how they are dealt under the insolvency and bankruptcy code. If you see the provisions of Section 18 and 25, IRP is responsible to compile all the claims which are made by the creditor in response to the public announcement. However, if you see Section 18 or 25, none of these provisions require the RP to verify, admit, or reject allegations. Regulation 13 gives a responsibility to verify. RP has to reject time barred claims of creditor whose debt is owed by the corporate debtor is a very interesting subject. And this issue was flashed in the Swiss ribbon matter also before the apex court. And it was stated that the power of the RP is administrative and is not quasi-judicial. And by virtue of this ruling, the question which kept on hunting to the RP was whether they must accept claims of various creditor even if they are completely time barred. Let us understand it from all 360-degree perspective. When CD becomes insolvent and CIRP starts, and the insolvency professional is appointed as a IRP, adjudicating authority under section 13 of the IB code makes a public announcement, public statement of beginning of CIRP, and IRP invites claim for submission, and the public announcement is done. If you go to regulation 6(2)(c), it asks you to submit proof of claims within 14 days of the appointment, and different types, as we have understood in the beginning of the session, are required to be submitted to substantiate the claim amount. In the matter of Grasim Industry versus Edelweiss Tech Pro System 2019 judgment of Supreme Court, where it was observed that regulation 30(13) makes a mandatory duty to verify every claim and maintain the list of creditor containing the name along with the amount claimed and so on the RP. Applicant claim was denied by IRP on the ground that claim amount was subject of arbitration before the arbitral tribunal, and the NCLT upheld the IRP's judgment. Appeal was filed before NCLAT, and it was a combined appeal. There was separate appeal arising from the Prasad Gempex versus Star Agro Marine Export Corporation, and Srei Infrastructure versus Kannan matter was also. So it was a bunch of appeals which were being discussed by the NCLAT. And question that was framed by Honorable NCLAT was whether the RP has a jurisdiction to decide or reject the claim of the financial creditor or the operational creditor. NCLAT observed the RP does not have the authority to decide the claim of one or more creditor, including financial creditor, operational creditor. Power of RP was not adjudicatory. RP is responsible for vetting and verifying the claims and determining the value of each claim, as opposed to the power of a liquidator in the liquidation proceeding, where he has a responsibility to consolidate and verify the claim and either admit or reject the claim under section 38, 39, 40 of the code. Again, in the matter of SR Steel versus Satish Kumar Gupta, it was reiterated that powers are not adjudicatory but administrative. All claims must be submitted to and decided by RP so that the prospective resolution applicant knows exactly what has to be paid in order that it may then take over the business of the corporate debtor and run the same as per the resolution plan. Now, let us understand it from a time barred perspective. Who has the authority to reject the time barred claims, whether IRP or RP? Or how we should consider the express inclusion of section 238A regarding the principles of limitation applicability. IRP or RP to admit claim it was not the intention of 238A. 238A makes the Limitation Act provision applicable to actions or appeals before adjudicating authority or appellate authority. The provisions of section 238A do not encompass claims verification by RP under regulation 13. So the statute remains silent on applicability of the law of limitation on the process of claim verification by the RP or IRP. Now, although the limitation law has not been specifically declared relevant for the purpose of regulation 13 of the CIRP regulation, but it cannot be overlooked also, as has been stated in many of the judgment. Once the claim is time barred, the debtor is safeguarded by law from a legal action brought against it to recover the claim. CIRP regulation draw a distinction between the amount sought by creditor and the amount of claims admitted under regulation 13. The provision which presumes that IRP will use the best judgment to allow only those claims which are legally permissible. If you see section 3 clause 6, which is defining the claim,
It's legal.
yeah. Therefore,
Hello.
yeah, sorry. Yeah, you are saying something?
Is legally acceptable claim.
Yeah.
That means that is legally enforceable.
Those which are legally enforceable, those are to be taken into consideration. Now, considering the stance that IRP or RP has no choice but to acknowledge the time barred claims is a very tough notion to justify. when these claimants whose claims are barred by law of limitations are not allowed to file time barred claims in the court of law for the purpose of recovery, how they will be in a position to file their claims for the purpose of recovery of their money from a company which is ailing under the CIRP proceeding and struggling for its revival. Something which is not possible to be done directly should not be done indirectly also. That is a well settled principle of law. If a creditor who is time barred cannot trigger insolvency by filing an application under section 7 or 9, he should not be allowed to participate in the corporate debtor insolvency process by coming indirectly also. That is the analogy given in the one of the judgment. When allowing a time barred claim to be satisfied, it would be place an undue burden on a prospective resolution applicant who wants to bring corporate debtor back to the life. Now, adjudication of a claim under the code is a legal process by which right to claim against the corporate debtor is to be decided by proper authority, whether it is the RP or IRP or the adjudicating authority. If you review different aspects under the bankruptcy law and the judgments, we can conclude that IRP or RP has authority to rule on admission or denial of a claim, and it would be considered as the administrative function only. Because just because that he is exercising a decision on the subject matter, whether it is time barred or not, will not make it a quasi-judicial function. That was falling from many of the judgment, including Navneet Kumar Gupta in the matter of Monet Power versus BHEL, as well as many other matters which are decided maybe in one of the matter of S. Rajendran, who was a RP of PRC International Hotels.
Suppose, hello.
Yeah, please.
Suppose in case this time barred claim is admitted by ignorance or by whatever means, who can challenge? Whether the fellow financial creditor, operational creditor can challenge, or corporate debtor can challenge, or if it is has gone to the extent of RFRP,
I
then
think this matter has been deliberated in many of the matter. I think I don't see any reason anyone's like fellow claimant also have a right, because their rights are getting affected because of this admission.
yeah,
Even corporate debtor, if existing directors, through them they are filing an application and they want to make an objection, I think they can also make the objection. I don't see any restriction on filing of the objection, and that has been stated in one of the celebrated judgment also, that the law is so very beautifully crafted that there are inbuilt checks and balances principles, where committee of creditor is headed by an insolvency professional, but he has not been given any voting right. So voting rights are given to all the creditors by purpose is to create a check and balance between the insolvency professional and the committee of creditors. Similarly, the IRP has not been given unfettered power. There are certain actions which are required to be taken through the approval of the committee of creditor also. Similarly, here also the law has inbuilt system of checks and balances. So the who is coming for a trigger, the I think regulator has never came for the purpose of stopping anyone from the purpose of adjudication. I think adjudicating authority is empowered enough for the purpose of taking whether the cognizance of such kind of appeals or disputes have to be taken into consideration or not.
Even if it has crossed all these filters and it has gone to the level of successful resolution applicant, then subsequently if he verifies and finds that it is a time barred claim, then he can
I
also
think
challenge.
I
It will be
think
difficult to
yes.
go to such extent.
Huh. Yeah, but you will have to see in all situation the bona fide has to be there, right? If you are sitting something on something for 2 years, 3 years, when you were aware about the same, I think your intention and your bona fide is also to be examined by the adjudicating authority as to why you were, despite knowing everything, you have not raised the question at an earlier stage. Now you are coming to disturb. If it is the idea, then perhaps court might ignore that. But if you are having a bona fide reason by virtue of which you were prevented from raising that claim or dispute against such kind of admission or non-admission at an earlier stage, I think court even can consider that at a even later stage, while even considering, and that's the precise reason why you are seeing n number of litigation. I am aware about one of the matter where the resolution plan approval application is being considered, and it is restricted by almost, I think, more than 150 applications which are ongoing, and unless and until these applications are decided, the subject matter of approval of resolution plan obviously cannot be disposed of. So that is preventing and delaying the approval of resolution plan as well. But yes, because it has to be seen on the case on case basis. So many a time these kind of litigations keep on hammering in many of the situations. I think that's the reason. Coming to, I think on arbitration, I think we can see few more precedences if we can see. Uh, One more judgment of Sunflag we can take up. Sunflag Iron and Steel Company versus Poonam Chand and Sons. The issue involved was, can the arbitrator be appointed while insolvency petition is pending? I think we have discussed this. This, if arbitration, if a insolvency, no, we have insolvency petition is pending. I think, I don't know. In this matter, this is a very unique matter where the Bombay High Court has clarified the position regarding the appointment of arbitrator during the ongoing insolvency proceeding, and it was held that initiation of proceeding under section 7 of IB does not preclude the appointment of arbitrator under section 11(6) of the Arbitration Act. Bombay High Court held that bar under section 238 of IB applies only after NCLT has admitted section 7 application. Until it is admitted, you are free to explore the other alternative remedies as well. And the same issue, I think, was decided by Delhi High Court in the matter of Millennium Education Foundation versus Educom Infrastructure and School Management. Now, mere pendency of insolvency petition will not debar. Another subject which was, I think, very interesting, can the CIRP be initiated if arbitration proceedings are ongoing and no arbitral award has been passed? This was a matter which was decided in the matter of Pitambar Solvex versus Manju Sharma, Delhi High Court ruled that mere initiation of the arbitration proceeding does not bar the corporate debtor from pursuing the other remedies under the insolvency law. Similarly, in the Chennai Metro Rail versus Lanco, the Madras High Court has also held that Section 33(5) of the IB, there is no requirement to obtain the leave from the adjudicating authority to continue the arbitral proceeding. High Court has held that the power to grant leave inherently includes the power to deny. Similarly, the Reliance Commercial Credit versus Ved Cellulose, the adjudicating authority of Mumbai, has held that the pendency of the arbitration proceeding does not bar the commencement of CIRP. So that is clear. Another important aspect was, can arbitral tribunal pass an arbitration award during the CIRP process? Now this was interesting because this could impact the claims. This was a matter decided in the Atul Raj Wadekar versus HDFC Bank, and adjudicating authority considered this question.
Can you tell the case, please?
This
Atul?
is Atul Raj Wadekar versus HDFC Bank. Right. In this matter, the adjudicating authority held that arbitral award violated the objective of insolvency and bankruptcy and will be considered to contravene the moratorium provisions under Section 14, and the arbitral award was set aside. Similarly, in the Ranjit Das versus MSX Mall Private Limited, NCLAT took a different instance, and appellate court allowed the continuation of arbitration proceeding and held that while the proceedings could continue, any award which is passed by the arbitral tribunal against the corporate debtor cannot be given effect to. So in that respect, the previous order was considered as bad under Section 14. One more issue, I think, which came up for discussion was, can a CIRP be initiated if arbitral award has been passed, but it is still pending a challenge under Section 34 or 37 of the arbitration law? Supreme Court in the matter of K. Kishan versus Vijay Nirman discussed this scenario where operational creditor was given a favorable arbitral award, which was challenged by the judgment debtor under Section 34 of the Arbitration Act. And while the proceedings to set aside award were still pending, the operational creditor approached the adjudicating authority to initiate the insolvency proceeding based on the arbitral award. Now, Supreme Court held that ongoing proceedings to challenge the award therein constituted a pre-existing dispute, which preclude the operational creditor from filing a insolvency application until resolution of challenge under Section 34 or 37 of the Arbitration Act. However, while Supreme Court was seized of the same matter in the case of Kotak Mahindra Bank versus A. Balakrishnan, clarified that this restriction does not apply to the financial creditor. If a financial creditor obtain a favorable arbitral award or a court decree, a fresh cause of action will arise and a valid proof of debt for initiation of the insolvency proceeding can be considered, and the financial creditor will not be hit by the principle of pre-existing dispute, and so can initiate the proceeding, and he need not wait for the disposal of section 34 and 37 appeals as well in this particular manner. Another matter which could be immediate corollary: can the CIRP proceedings be initiated on the basis of arbitral award? This subject also has been several to subject of dispute, wherein it was mentioned that insolvency proceedings can be initiated by a financial creditor, operational creditor, or the corporate debtor himself by the primary trigger of a default. So the precondition is default. Unless you meet the precondition, the trigger will not happen. Under the Insolvency and Bankruptcy Code, the award holders are considered as creditor, whether they are operational creditor or the financial creditor. The key of requirement of CIRP is the existence of debt that has gone into default. If you read section 311, 312, CIRP can be triggered only when CD fails to pay crystallized obligation or liability. And 310 defines the term creditor as any person to whom the debt is owed, which can be financial, which can be operational, which can be secured, which can be unsecured, and it includes a decree holder also. Section 36 of the Arbitration Act, when the time for filing an application to set aside an arbitral award under section 34 has expired, the award must be enforced in the code of the civil procedure. That is the mandate under section 36. This means once this period of challenging the arbitral award has lapsed, the award is treated as if a decree of the court and can be enforced. Now, if it is a domestic award, the situation is different. If it is a foreign arbitration award, the situation is different, because the instance of it becoming a debt is different. Because in the matter of Dena Bank versus Sivakumar Reddy, Supreme Court observed that the final judgment or decree from the court, tribunal, or the arbitral award, if unpaid, constitutes a financial debt under the Insolvency and Bankruptcy Code. And this will enable the creditor to initiate the CIRP proceeding. Supreme Court also observed that once the claim is converted into a final judgment or decree and a recovery certificate is issued authorizing the creditor to collect the dues, the creditor acquires the renewed right to recover amount specified in the judgment, decree, or the recovery certificate. In this matter, Supreme Court held that the judgment or decree for money in favor of the financial creditor passed by DRT or by tribunal or by anyone will be considered as a fresh cause of action. If you see the foreign award position, the foreign award treatment is a bit different and it is little complex. Unlike the domestic award, the foreign award must undergo additional process for enforcement to make it binding on the award debtor in India. This matter was discussed in the AgroCorp International versus National Steels and Agro Industries. NCLT Mumbai permitted the foreign award holder to initiate CIRP based on the foreign arbitral award without enforcement decree. And in this matter, tribunal applied section 44 of the 44A of the CPC, which deals with the enforcement of foreign decrees in India. And adjudicating authority reasoned that the foreign award was executable in India simply because it originated from the reciprocating territory as referenced in section 44A of the Code of CPC. And this decision was obviously criticized left, right, center. And subsequently, in many of the matter, the observation was reversed, like Aditya Engineering was one matter where without enforcement decree, the CIRP was not allowed to be commenced. Supreme Court in the Government of India versus Vedanta confirmed the view of NCLT in the matter of Aditya Energy Resources, rejecting the view of Bombay NCLT in the matter of AgroCorp International. And it was held that foreign award is not automatically decree. It will become decree only when court determines its enforceability under Part 2 of the Arbitration Act. It was held that allowing CIRP based on the foreign award without its enforcement would undermine the procedural framework under the Arbitration Act and will confer the legal challenges as well. So these are the few of the judgment. One more matter which can be deliberated is whether arbitration can be invoked after commencement of CIRP or during the commencement of CIRP. I think though we have discussed in one of the matter, one more judgment is coming to my mind, is regarding the Alchemist Asset Reconstruction Company versus Hotel Godawan Private Limited. Supreme Court dealt with this issue and held that once the moratorium is in place, as per section 14, no new suit arbitration proceeding can be initiated against the corporate debtor. Continuation of any existing suit or legal proceeding is also prohibited. And Supreme Court held that the arbitration proceeding in question were non-est in law. And the rationale behind the decision was to uphold the purpose of moratorium, which is to create the period of calm during which creditor cannot take individual enforcement actions that could potentially undermine the objective of CIRP. And court highlighted the prohibiting the disposal of the corporate debtor asset ensures that debtor or its management cannot deplete the value of the company. Therefore, this judgment was considered. And similar, there are many of the matter in which this judgment has been given effect to. So if we conclude the summary of arbitration, as far as the initiation of the proceeding is concerned, we can say that mere existence of arbitration clause will not bar the initiation of insolvency proceeding. Arbitration can be invoked until CIRP commences or the application under section 7 has been admitted. Presence of ongoing arbitration proceeding does not necessarily constitute the pre-existing dispute preventing the initiation of the CIRP. It will be examined in the admission petition of the CIRP. Regarding arbitral award and the insolvency, yes, arbitral award is the basis for initiating CIRP, provided there is no challenge. So after the challenge period is over, yes, it is dead due and we can do. For foreign award, enforcement decree will be required to be obtained before commencement of the CIRP. Moratorium, if I can consider, then for moratorium, once the CIRP is initiated, moratorium is in place, new arbitration proceedings will be prohibited. Existing arbitration proceedings are generally stayed, but there are certain exceptions where they have been allowed to continue, provided they does not create any charge on the assets which are existing. Post-resolution plan, after the resolution plan is approved, no new disputes can be referred to arbitration against the corporate debtor. That is clear. And on the last subject, jurisdictional issue, the adjudicating authority will lack the jurisdiction to set aside the arbitral award, even if they are issued during the moratorium period, although that will not be required to be considered for any matter, because that's unenforceable in any case until you are free from the clutches of the CIRP. These are few of the judgments which are very relevant. I think let me just see if we can see a couple of more matters with regard to the claim specifically. On the claim, yeah, one more judgment, I think. In a resolution plan, should a resolution plan necessarily provide for value equal to or greater than liquidation value to the different set of creditors? In State Bank of India versus Accord Life Spec Private Limited, 2020 order, and it was held that the resolution plan may not necessarily provide the value which is equal to or greater than liquidation value arrived at in a manner provided under regulation 35 of the CIRP process regulation. Liquidation value may be a benchmark to see whether the resolution plan provides a better value to the creditor than what they would have got in the case of a company was liquidated. However, law does not bar acceptance of a resolution plan which does not match with the liquidation value. I think this is quite a settled view. RP adjudicating power, I think SR Steel judgment is final. Whether resolution applicant has a right to receive complete information about the corporate debtor that owed that regarding the debts owed by it and its activities as a going concern. This was again in the matter of SR Steel. So the resolution applicant has all right that was affirmed in this matter also. I think, yeah, one more point, I think last point we can take, whether the secured creditor and unsecured creditor can be treated equally. This matter also came up for discussion in the SR Steel, Satish Kumar Gupta, and it was held by Apex Court that there exists a clear demarcation between unsecured and secured creditor, as well as between the financial and operational creditor. The financial creditor provides capital to corporate debtor and in turn will acquire interest or charge on the assets of the corporate debtor, whereas the operational creditor is just a supplier of goods or services to the corporate debtor, which gets paid in return. Therefore, treating unequals equally would defeat the purpose of the code. That was a judgment given in the Satish Kumar Gupta. One more incidental, I think, issue which was discussed in this Satish Kumar Gupta matter only, whether financial creditor can recover money from the guarantor after approval of the resolution plan. Now, NCLAT in its decision has extinguished the right of the creditor against the guarantor once the resolution plan was approved. However, Supreme Court set aside the NCLAT order and stated that resolution plan was binding on all stakeholders, including guarantor. Even after the amount is paid to the creditor under the resolution plan, they can chase the guarantor for the remaining claim. That does not stop them from chasing their claim separately if they have a remedy available within the time frame and they want to complete the recovery process. In separate proceeding, they can do so. I think that's it. We have covered limitation, we have covered arbitration, we have covered time barred. I think I am done with my bit of discussion. Maybe we can take up some of the questions or experiences from the professionals and then we can wind up. Yeah, please.
Excuse me, sir.
Yeah.
Sir, one of the financial creditor claim has been admitted subsequent to formation of COC. So what about the CRP expenses? From which date he has to share it?
CIRP expenses you are talking about, from which date he has to know. CIRP expenses will be, if you see, CIRP expenses are as far as expenses interregnum period are concerned, right? Now, we don't know
Yes.
what will be the fate. Ultimately, CIRP expenses are to be paid off by the either successful resolution applicant, or they'll be
Financial
paid,
creditor.
or no, financial creditor or anyone is paying only in the interregnum period. Please understand. Ultimately,
Yes.
who has to bear? Ultimately, there will be a charge against the assets of a company and they will be paid in first priority as per section 53.
Yes,
Right?
yes, yes. Yes.
Now, if you pay in part or if you pay in full, or one of the financial creditor is paying, ultimately they will be settled at the time of 53.
Yes, 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 yes.
And likewise in the resolution plan also they will be settled in
Yes.
that manner only.
Yes,
So
yes, yes.
as far as somebody can say ki bhai, since I have joined the process today, so
Yes.
I am ready to bear my bit of expenses, whatever is now coming to
Yes, yes.
CIRP expenses now onward.
Okay, okay.
So he is right in doing that.
Yes,
And
yes.
the larger principle which I advise that in any which case, they are to be borne by the successful resolution applicant as a resolution cost or
Yes.
as a CIRP cost during the liquidation. So accordingly, it does not really matter because it will be, so somebody should not be biased on many times. I think the education issue is there with the financial creditor, especially the bank. They are little hesitant in sharing all these
Yes, yes.
expenses, and the insolvency professional is in difficulty and in the lurches in meeting out the insolvency and the liquidation process. So
Yes, yes.
unless and until he is having the apprehension that there are no assets and ultimately it is going to be a sunk cost, that's a
Yes.
different matter.
Okay, sir.
That is
Okay.
the case, then I think he can take his judgment. Otherwise, there is no difficulty.
Okay, sir. Thank you.
Sir, in liquidation, after the last date of submission of claim, if some claims are received, whether the liquidator is bound to consider that or he can reject that.
Generally, in case of liquidation, whatever timeline is provided, I think the wording which is used in the liquidation regulation, although I have came across one of the judgment of NCLET, wherein it was stated that the liquidator should not exercise his power mechanically, and he should not interpret the provisions in isolation. He should also exercise some of his wisdom, and he may consider the cases on the genuine basis to reduce the burden of the adjudicating authority as well. This is also mentioned, but generally I think none of the liquidator is taking a burden on him. He will reject the claim and he will request the adjudicating authority to intervene into the matter and decide. And generally, if it is only a matter of delay, I think I have seen the allowance by the adjudicating authority until maybe 70% of the distribution was done. One of the claim was received after distribution of 70% of the assets. 30% were only remaining. Still the claim was admitted because that was a genuine case, and the person was prevented from filing the particular claim. So I don't think that there should be any difficulty. But to be your question on the particular point, I think the view is settled, and majority of the people are taking a call that we look upon the adjudicating authority to intervene into the matter for the purpose of admission rather than
The claimant has to approach the adjudicating authority.
yeah, that's correct. There are although couple of matters where the liquidator has also filed some application in the matters where he just wanted to complete the process in a fast track manner because the applications were multiple. A group of people were prevented. So instead of they were not able to come to a common platform to file that application, the liquidator in that matter has initiated that process for seeking necessary application approval of the adjudicating authority as well. Yeah. Anything further or any other point that you want to bring in? All right. Anybody from ICSI, IPA?
Myself, sir.
Yeah, please. I think I'm done with and we have taken up.
Acha, from host, huh? Okay. I think, yeah.
Hello.
Yes, yes.
So we can wind up if you want.
Yeah, we have completed. I think you can close the proceedings and we can conclude.
But it is quite interesting, sir. You have referred so many cases, and it has given us a lot of good enlightenment on claims issues. Thank you very much, sir.
I've only shared the cases are created by many of the insolvency professionals in the past, and it is their effort that they have let this law evolve over a period of time. I'm only sharing those cases with all of you so that we can take appropriate decision in the subsequent matters.
Are you sharing the details? Are you sharing this PPT or material?
I have not anything structured, but I'll try to compile. It was not since in a presentable format, so I have not shared that. But I will certainly do some compilation and I will share it out to IPA, and IPA will share it out to you. I will do that.
Thank you.
All right, sir. Thank you. Thanks to all
Thank you.
for all your time and
Thank you
the
very
contribution learning. Thank you so much. Thank you.
Thank you, Amit.
Thank you, sir. Thank you for your sharing your experience and learnings and making this session interactive and insightful.
Thank you.
Thank you.
Very interesting.
Thank you.